Now we go to the second ground for analysis. This is section 327 of the Companies Winding Up and Miscellaneous Provisions Ordinance. If you look at 327 and compare it to section 177 of the same ordinance, you'll see the provisions are identical. So essentially what this means is that the Hong Kong courts may take jurisdiction to wind up any company, regardless of where it is incorporated, provided that it is unable to pay its debts, for example, or in our case, because we're looking at unfair prejudice, it is found to be fair, just and equitable to wind up the company. So when it is established that the company's winding up will be just and equitable, then the court really need not look farther, and the court could wind up the company, regardless of where it's incorporated, and take full control of that process under Hong Kong law. However, there are judicially crafted discretion rules to prevent the door from being quite so open to the Hong Kong court. And these are found in the Beauty China Holdings decision and a number of other decisions which are cited. So what we're looking at are primarily three factors, right? So I have it here in 4, but it's considered to be a 3-factor test with 1 and 2 being combined. I've opened them up simply to emphasize the analysis. So first of all, there has to be a sufficient connection with Hong Kong to justify the court setting in motion its winding up procedures over a body which was created by foreign law. And in the context of insolvency, there is commonly the presence of assets, but that is not essential, right? So this is the sufficient connection, which is normally going to be assets. The second criteria will be the possibility that the winding up order will benefit those that apply for it. And that's connected to the third criteria in a normal situation where a creditor is seeking assets, in that the court must be able to exercise jurisdiction over one or more persons interested in the distribution of the assets, i.e. the owners of the assets that will be distributed to the creditors, and the creditors would be those who benefit from the application. Okay? So we have sufficient connection, which in most cases will be the presence of assets, and the benefit to the petitioner, which will be connected as well to the possibility of the court taking jurisdiction over the person which has the assets. Now, in the Young Key case, we have an application of this which emphasizes that the sufficient connection will be somewhat context-oriented. What we see in paragraph 28 of the Court of Final Appeal decision is that from the dearth of authorities on such petitions, it would appear that shareholders' petitions against foreign companies are a rarity, at least in England. And the court emphasizes that in these sorts of cases for unfair prejudice or just and equitable winding up, we will have a relatively close relationship between the members, which could be a family firm, and that in the UK, family firms will not necessarily, it'll be unlikely that they are foreign incorporated. They'll be using UK law and not foreign law. However, in Hong Kong, it's actually quite common that the companies with this sort of family presence could be incorporated abroad, such as the Cayman Islands or Bermuda or the British Virgin Islands in our case. So Hong Kong is different because its economic structure is different, and the way business is done and structured is different. So this is important because it allows the court to emphasize its own common law development, which is not going to be identical to the UK. And we discussed this last week when looking at the Luck Continent decision. So now let's take a closer look at what happens under Section 327 when we're deciding whether a company is liable to be wound up under the Cap 32, which is the Companies Winding Up and Miscellaneous Provisions Ordinance. So in China Medical Technologies, what we have is, first of all, the Court of First Instance finds that it should not take jurisdiction. Then the liquidators in the Cayman Islands who have brought the matter to the Hong Kong court. Again, we have a Cayman Island court because we have liquidators that are operating with the authorization of the Cayman Island court. And that Cayman Island authority is seeking Hong Kong control of the winding up procedure of the company. And they're doing so primarily because China Medical is a company which was listed on NASDAQ and was actually quite successful. However, it went bankrupt. And if we look at the structure, we have the Cayman Island Company, which owns a couple of British Virgin Island companies, which in turn own a few Hong Kong subsidiaries. And these Hong Kong subsidiaries own mainland subsidiaries, and the entire thing is developing and selling medical technology. And then what our question is whether the Hong Kong court can take jurisdiction over the winding up of this Cayman Island entity, which was a listed company, not in Hong Kong, but in the United States. And why the Cayman liquidators want to bring that into Hong Kong is because they have evidence that the directors of the company have entered into transactions in mainland China which have depleted the company of millions of dollars of assets. And so what they really want to do is ask some questions and do some investigation with the directors who are in Hong Kong. And the jurisdiction, as you would expect, is disputed exactly by one of these directors, because if the case does come into Hong Kong in this form, that director will be subjected to litigation pursuant to the Hong Kong proceedings. The court originally found that there were not sufficient contacts and the other criteria in Hong Kong because the only creditor in Hong Kong had a credit of 4,000 US dollars. That's not a lot. The liquidators in the Cayman Islands later brought to the attention of the court before the judgment was final that there was evidence of this removal of assets by the directors who were in Hong Kong and asked for the case to be reconsidered. And the Court of First Instance found that the company indeed should be subject to the Hong Kong courts. This was disputed, and the Court of Appeals took the case. So the question at the CFI is basically, what are these core requirements, right? And the argument of the CFI is that the core requirements are discretionary. That is, they do not determine whether the court may take jurisdiction. but rather they open up the possibility of the court to exercise its discretion not to take jurisdiction. So if the requirements were, say, statutory, then that could mean that if we do not have a sufficient connection, jurisdiction over someone that is connected to the proceedings and benefit to the petitioner in Hong Kong, then the court must reject jurisdiction. However, as we saw, Section 327 essentially opens the door to Hong Kong without setting any criteria except for the fact that there be a ground for winding up, such as inability to pay debts or the just and equitable winding up argument. And then this is disputed at the Court of Appeal. But beyond that, it's a matter of whether each of the criteria must be satisfied, or whether the sufficient connection criteria is enough to bring the case into Hong Kong. And as I said, at first go, the Court of First Instance rejected jurisdiction. At second go, and that was not finalized, then they accepted jurisdiction. And this is what was disputed at the Court of Appeal. When the Court of Appeal looks at this, there are a number of main arguments, right? So the first argument was this point about what the Beauty China criteria, how strong are they? Will they be binding on the court, or do they simply open up the court to exercise discretion to take or refuse jurisdiction? And the Court of Appeal decides that these criteria simply go to discretion. They help guide the court in deciding when to let the foreign matter into the Hong Kong courts, given the fact that 327 is wide open. And so this is something which is court-made, and the court is rather free to decide how binding it is. And then the question is, what happens if, let's say, the criteria about a creditor being satisfied, a creditor in Hong Kong being satisfied by the winding up? If that criteria is not met, and as I said, what we have in this case is the only Hong Kong creditor is a creditor that holds a credit of $4,000, relatively insignificant. And this is the argument raised on appeal. However, what the court finds is that the primary analysis is the first criteria, as it's expressed by the court, a single overarching question: whether there is sufficient connection between the company and Hong Kong for the court to take discretion. The third issue is similar to what we see in Young Key, and that goes to the flexibility of the analysis. So what was important in Young Key is the Court of Final Appeal shifted its analysis to the connections that regarded shareholders rather than the connections which regarded creditors, because the petition was filed by a shareholder for unfair prejudice. And here what we have is a petition which is filed by the company itself, led by its liquidators, who are empowered by the Cayman Court. And the Cayman Island Court is the body which administers the law under which the company was created. So in this particular case, we would analyze the connection differently than if a creditor were filing the petition. If a creditor were filing the petition, then the creditor would be primarily interested in assets. And so the presence of assets and the presence of that creditor or other important creditors would be very important. But in this case, what's being gained is the ability of the liquidators to go after the directors who they suspect drove the company into insolvency. So in Young Key, we have one angle, which is to look at the connection of the members, because the members are bringing the case. In the run-of-the-mill winding up decision, we would look to the creditors, the presence of the creditors, the substantial size of the credits. And in this case, we're looking to the particular desire of the company itself to bring an action that would bind the directors who might very well have misbehaved, driving the company into insolvency. Now, a bit of review. If we think about the clarity of Hong Kong court jurisdiction and then the connection to Hong Kong law, we can plot this a bit. So a registered Hong Kong company clearly has crystal clear jurisdiction within the Hong Kong courts. And the connection to Hong Kong law is at its maximum. If we take a foreign company which is registered under Part 16 of the Companies Ordinance, it has some connection to Hong Kong law because it is complying with the registration process. And we have a clarity of jurisdiction over this company, which is basically the same, at least for Part 14, as a company which is incorporated in Hong Kong. If we go from there to a company that we have to try to find out factually whether it has a place of business in Hong Kong, we're looking at a company that is completely unclear because the analysis for place of business is difficult. Many factors are included in the analysis. No factor and no particular cluster of factors is going to be guaranteed to be determinative. So the connection to Hong Kong law could be extremely minimal and the clarity of the court's jurisdiction minimal. The last option is what we've just looked at, and that is the winding up of an unregistered company under Section 327, and also the application of the three-factor test from Beauty China. And in this case, we have more clarity because we now know from the Young Key and from the China medical cases that we look to the petitioner of the action, what they are trying to achieve, and we understand that we'll use that to analyze the sufficient connection. And we also understand that the sufficient connection test is the overarching and most important factor among the three-factor test. The connection to Hong Kong law is also slightly larger because if we are looking at an action that involves creditors, then the debt itself should probably be governed by Hong Kong law. So we're looking at something which will be a Hong Kong law contract in the case of a creditor petition, and in the other petitions, less so. That is the law of foreign companies in Hong Kong. These non-Hong Kong companies are governed by certain aspects of Hong Kong law in order to protect investors in Hong Kong. And two routes exist for jurisdiction. One is a finding of a place of business, which will trigger application of Part 14. And the other is a finding that the unregistered company, the foreign company, may be wound up under Hong Kong law, and that will allow a just and equitable winding up petition, which is essentially identical to a finding of unfair prejudice if the relief sought in the unfair prejudice petition is to wind up the company. I look forward to discussing this with you. This will be our last lecture for this course. It's been very interesting. I hope you found it to be interesting as well.